I'm Megan Rusciano. I'm an attorney with Disability Rights Maryland, and I work primarily in our developmental disabilities unit. So I do work on a lot of helping folks either become eligible for DDA services or helping them access DDA services once they are eligible. That process doesn't always go as smoothly as we would hope. So I can step in and help do that. But I also work on supported decision-making as an alternative to guardianship. So how many of you are familiar with the word supported decision-making? Have you heard it as a term? Raise of hands. One. Okay. Well, we will start, I'll give a little bit of context about what it is and how it works. And we'll kind of work through how it can be an alternative to guardianship for folks with disabilities. I always have to have my disclaimer that this presentation is not providing legal advice. It's a good attorney in me. So as far as what we're going to do, we have a jam-packed PowerPoint that I hope to keep interesting. I've left ample time, though, for questions, so please feel free to stop me at any point. We're going to start by kind of, like I say, laying the foundation, so talking about an example to kind of get in the back of your head about supported decision-making, and then to kind of run through definitions. So what is it, how it works? We'll talk about how it works in practice. We'll talk about why it's important. We'll talk about some other alternatives to guardianship that exist, takeaways, and leave time for questions. And there's also a resource page at the end. So how many of you are familiar with guardianship? Okay, more hands. Okay, that's what I just wanted to make sure that our terminology, we're all on the same page. So to kind of start, I'm going to give you an example that I kind of just want you to think about, keep in the back of your head, or maybe you probably have your own examples too, as we're moving through this PowerPoint. But I'm going to use a woman named Susan, hypothetical woman named Susan, who is nonverbal. So she doesn't communicate orally. She communicates using gestures and eye contact. And I'm going to read now. Unfortunately, I don't have it printed out, but I'm going to read from a document called Expression of My Wishes. So before I worked at DRM, I worked for a brief time in Vancouver, British Columbia, and they are actually the first jurisdiction to pass a law promoting supported decision-making. And so part of what we did was work on helping people figure out how best they express their wishes, helping people document how the people they support do that. So I'm just going to read this so that you have an idea about how Susan communicates. And I think it's something helpful we'll talk about later to keep in mind about the people that you support and maybe making one of these, because people do communicate in non-conventional ways, and it's important to document that if they do. So this is Susan saying, I communicate using gestures, gazing, and sometimes reaching. I was learning cause and effect on a computer touchscreen. I was learning if I reached out to touch the computer screen, I could make the picture on the screen change. I'm not always able to make my hand do what I want because I have a lot of seizures which interfere with my thoughts and abilities. I express pleasure by smiles, eye contact, and most often by bouncing my right leg up and down. I will comply with simple tasks requested of me when I am content, such as reaching for my drink cup when requested to do so, and if I'm thirsty, pushing my arms into my sleeves when I'm asked. I express displeasure with facial frowns and pushing people away with my arms. I don't enjoy having my teeth brushed and will try to push whomever is brushing them away. However, I usually give in and allow this to be done because my mom tells me I need healthy teeth and this is how I get them. I can be resistive to touch, especially of my left hand. I turn my face away and clamp my lips shut from unwanted food or if I need a break from eating. If I don't like a particular person, I will hide my face in my arm or put my head down to my chest and refuse to make eye contact. I like swimming, free time sitting independently on the floor, horseback riding, group functions, working with pottery and clay, sleeping in, eating, bowling, listening to country music. And I show I like these things by bouncing my right foot, remaining alert, occasional smiles, vocalizing, making eye contact, and trying to participate to the best of my capabilities. I dislike bright sunlight and not having my sunglasses on, strangers and people staring at me, people talking about me as if I wasn't present, getting up early and being rushed to get ready for outings. I dislike having my ears cleaned. Me too. I show dislike by refusing to make eye contact, frowning, clenching my teeth, and pushing my caregiver with my arms. I will cover my eyes and roll my head into my arm to indicate I wish to put my sunglasses on. But if I do this in the house and it isn't sunny out, it means I want to go out. To indicate preferences when given a choice between two or more foods or objects, I will make eye or gaze contact to my choice. I need to take my time when doing this. I make choices about which shirt or sweater to wear, as well as lunch choices. Do I want to start the day with food or drink? After my morning medication, if given a choice to stay in bed or get up, I usually lay back down to show I like sleeping in, but there are days when I will stay sitting up to indicate I'm ready to start my day. I spend my leisure time at home watching TV or being with the family gathered around the kitchen table. I also really enjoy my special lazy boy chair. I am content and happy as long as I'm included in all family functions and discussions. I can be very vocal if I think I'm being ignored. So that kind of gives you an idea about how Susan communicates, how she expresses her wishes, her preferences, her choices. So she may be nonverbal, but as we know, people can communicate in different ways. That's how she does. So in this example, Susan lives in a group home in Baltimore, and she enjoys spending time with her friends and is looking for a job. She visits her aunt twice a year, but when she does, she expresses disapproval when she is there and is unwilling to engage in many of the activities when she is there. Susan's aunt wants to petition for guardianship and move Susan to Cumberland, where her aunt lives. How can supported decision-making help Susan? So this is something we're gonna kind of keep in the back of our heads as we move through. But to kind of understand what supported decision-making is and how that works with Susan, we need to define supported decision-making. And to do that, we need to talk a little bit about capacity. So capacity in this context refers to an individual's ability to make and communicate a decision. It's basically their decision-making ability. So it's their ability to indicate a will or a preference or and act on it. So Susan can do that, right? She can indicate that she's happy. She can make a choice through eye gaze. She can indicate those wills and preferences. But that may exist on a spectrum, right? Like anybody, we all may need less support or more support with a certain decision. I always like to say, it's really easy for me to make a decision about what I want for dinner, right? Because I love food and I'm Italian. It's very simple for me to do that. But if you're asking me financial decisions about how to invest my money or, so how to save more prudently, I'm probably going to need more help. And that's just, how I do that is I usually ask people around me, probably my brother, who's like a financial guru, what should I be investing in? How much should I be putting away? How does that all work? But I'm definitely not going to ask him what I want for dinner because I know that, right? So that's capacity. Sometimes you need less support. Sometimes you need more support. I needed more support to put together this graphic, which is just, really remarkable that the things can move. So that took me a very long time. I needed a lot of support for that. Okay, but that's generally capacity, right? But what about legal capacity? That's how we get into talking about guardianship. And legal capacity is a construct. It's something that lawyers and the law made up. And it determines what a person can or can't do under law. So some examples include whether a person can provide consent, so whether they can give permission to get documents or release information, whether they can make a contract, like whether you can sign a lease, whether you can sign a power of attorney. if a person has legal capacity, then their decisions are recognized under law. So I don't identify as a person with a disability. If I went in and signed my lease and no one said, Megan, you don't understand that, you can't sign it. Even though I probably didn't understand all the clauses in it, even though I'm an attorney. So everyone's presumed to have legal capacity, right? But historically with people with disabilities, that's come into question. A person, importantly, can lack legal capacity to make certain decisions, but not others. We see this a lot, especially around personal care and decisions versus maybe those tough financial decisions. People may be determined, it's not a all or nothing thing. It's not as though if you lack the ability to make one decision, you lack the ability to make all decisions. It can be very specific. So what is guardianship? If a person doesn't have this legal capacity, they're susceptible to guardianship. And in Maryland, there's two types of guardianship. There's guardianship of the person, which involves medical care, personal decisions, and there's guardianship of the property, which involves financial decisions. And usually you'll see those two things lumped together and people will just get full guardianship over a person. But if a person's under guardianship, they lose their legal ability to make certain decisions by themselves. So they ultimately don't have this final say of where they live. Unless it's preserved, they can't marry, they can't enter a contract. In some states, they can't drive. It's very limited in what you can do. And that's called substitute decision making. What that means is someone substitutes their decision making for someone else, makes that decision for them. The guardian acts for the person. They are responsible for making those decisions for the person. And something that people don't always remember about guardianship, they think, I was guardian of my child when, they were 17 because they were a child, and so just it makes sense for me to continue. Actually, when someone turns 18, they're an adult, and to pursue guardianship for an adult, you have to go through a legal process, and it's adversarial. So the person with a disability has an attorney appointed to represent their rights. It's a court process. You have to pay an attorney. And the court ultimately is the person who is the entity that oversees it. It's not as simple as saying, well, I just become guardian of, my child or my grandchild or whoever it is. Actually, the court is the final entity that has the say. So they make questions of medical decisions. You always have to report, if you're guardian, yearly about how you're dealing with their property and their finances. So it is, it is a process. It is a legal process. It's not just something you can do personally. So then what is supported decision making? I've mentioned it a couple times, but what does it actually mean? Supported decision making is an alternative to guardianship that lets a person keep their decision making authority without having to appoint a substitute decision maker or a guardian or someone else. So how does it work? People use trusted friends, family members, and professionals to help them understand situations and the choices they face so that they can make their own decisions. And it really allows for them to increase self-determination and empower them. So that's like a little graphic of how it kind of spaces out. But all that sounds nice. How does it actually work in practice? So supported decision making really involves a person selecting who they want on their team. So it can be just a single other person or it can be a whole group of people. And those people help them think through, make decisions, and help those decisions actually come into fruition, effectuate them. The supporter's role is to ask questions, listen, provide advice, translate. I say translate because people, may communicate in different ways. So, if Susan came into my office and wanted to talk to me and started bouncing her right leg up and down, I would think that she was nervous and was uncomfortable. But actually, people closest to Susan know that's how she expresses that she's happy, right? So a supporter of Susan needs to translate to me, well, she's indicating right now that she's happy, that she's approving of what you're doing. That's the role of a supporter. And ultimately, the most important role is to respect the person's decisions. So people should be empowered to make their own decisions. Sometimes they just need a little help. I think part of what we'll get to later a little bit is about dignity of risk and the ability to people to kind of learn from their mistakes and make not so good decisions so they can make better decisions down the line. The most important thing about supported decision making is the person keeps their ability to make decisions. And supported decision making really has become a national and international best practice that people are promoting as an alternative to guardianship. So the font went really small on this, but it's been endorsed by a number of organizations. The ARC of the US has endorsed it. The American Civil Liberties Union, even the National Guardianship Association has said, you should really look into this before you pursue guardianship. Yeah?
Sorry, I got in a little bit late.
Sure.
Are you waiting on questions till the end or as you go?
I can kind of take them as I go, as long as I don't get too bogged down, but we're pretty far along, so I can take one. Sure.
I mean, maybe it's later in here somewhere, so you can tell me.
Mm-hmm. Yeah, of course.
Later. I like this idea a lot, but what would happen in the situation that probably scares me the most is a medical situation. And you're in the hospital and, say my son needs something via needle to save his life.
Right.
I'm like, he's going to say no. Like, what happens then? Because obviously that no is not a no that understands all he's seeing is a needle that he knows is prescription and he doesn't like it. Like, what happens in that kind of emergent, or maybe not even necessarily, sometimes emergent, sometimes somewhat emergent, even if there's a few days of time.
Yeah, of time in between. Yeah, no, that's a great question. So I think, if you're dealing with it solely in the emergency, there are other tools. So you can have an advanced medical directive, or in Maryland, we have a surrogate decision-making law, which we'll talk about. We'll talk about both those a little bit later.
That's what I've heard about, and I would like to hear it from someone
yeah,
who has a little more practice and
yeah, and it's
exactly what that means.
It's something that hospitals and doctors aren't the best at realizing is the law, so I often tell parents to print out the statute.
Yeah, I've done that, but I guess want to make sure it really means what I'm thinking.
Yeah, if he's not able to make a decision, if the doctor's saying, well, he's saying no to this life-saving needle, and I don't think he really, doctors have to get informed consent, I don't think he really understands, then that comes into play. You can also do an advanced medical directive where that would come into play. But as far as, the longer term, if something isn't as immediate, you could do powers of attorney. There's nothing inherently except, by kind of trying to walk through with him now, there may be some time that you need a needle. Do you trust me if I say, will you trust my opinion if I say now's the time that you need it? Trying to kind of build that understanding across time. But there are safeguards that are available without having to go guardianship that can kind of step in now. So we can, if that answered your question, we can talk more too about that.
Later a little bit.
Yeah, we're gonna hit this. Yeah, this surrogate decision-making law. We will definitely hit that. So over 20 states have actually created supported decision-making laws. So right now in Maryland, there's no law that recognizes a supported decision-making agreement. Doesn't mean that you can't practice it and use it. But in many other states, they've actually gone ahead and done this. And so that gives legal authority to the supporter. That means when you walk into a hospital or you walk into a bank, you have some authority as a supporter. You can't make a decision for someone, but you can help that person walk through the decision, make sure they understand the consequences, make sure they're getting it. And it does give you some legal recognition, because sometimes we see, doctors or people saying you can't even be in the room. This makes sure that can happen. Why is supported decision-making important? So there's no tool that we have right now that does this exactly, that really supports people in making their own decision, helps them think through consequences. and kind of, get there on their own. And it is a natural transition from our person-centered reform. So all the DDA work that's been done around person-centered planning, it kind of tees up to this. In guardianship, if you think about it, you're appointing a guardian to act for you. So that person, or you're not appointing. The court's saying, this person's going to make decisions for you. In a power of attorney, you're often saying this person can make these types of decisions for me. It's not, they have to listen to what I say and help me make, think through the decision. It's usually they're going to act for you. You give them the power to act for you. It's not always the case, but that's pretty much how the statutory forms are written in Maryland. And then there's a surrogate decision maker. So I mentioned this in Maryland, and I'll mention it a little bit more in depth later too. In Maryland, there's a law that says if someone is incapable of making medical decisions, two doctors say, I don't know if you can make that medical decision, Megan. There's a list of people who can make decisions. And it starts, I believe, with spouse, adult child, parent is third, sibling, friend is there. And friend, we've gotten a broader interpretation of what friend can mean. We try to elbow a little bit about whether for people who don't have anyone in their lives, it can mean support staff. That person has authority to make medical decisions if the person's incapable. So it's this natural safeguard where you don't have to pursue guardianship if you're the right person on that list, because you'll just be able to make the decision.
So that copy that somebody gave me, is this still a valid Maryland
Yeah, I mean, I would
regulation or whatever
have to
book it's under?
see it. Yeah, I would just have to see it, but it's the same law.
That's what you just said, it was like
the list.
spouse, child,
Yeah.
parent, yeah.
And the Attorney General.
Attorney General's website.
Yeah, and the Attorney General actually has guidance on it. So then sometimes I also like to I print out the statute usually when I'm advising people, and I print out the guidance and try to get like a header that says Maryland Attorney General, so it looks professional.
I've been carrying it around since somebody gave it to me. I
Yeah.
just didn't know, is it still valid? Is it really gonna
It is
work?
still good law in Maryland, so it's, and that's, I mean, you kind of carry that around like you carry a power of attorney or an advanced medical directive, because that's your authority. So another reason why it's important is people with disabilities historically have been vulnerable to unnecessary guardianship, and supported decision making really gives them an ability to use supporters to help make their decisions rather than having someone make decisions for them. And it really can help people with disabilities refine their decision making skills. So I always say, if I was I marched along and I got to age 18 and I didn't make such great decisions. I was saying, well, I'm gonna go to school in Canada and then I'm gonna drive across the country and I don't know how I'm gonna pay for any of this, but I'm just gonna do it. And no one questioned that because they just, said, you're gonna get older and you'll start to grow and understand that that's not the responsible thing to do. And you have to make money and, that's not really gonna work. But I was allowed, right, to make these kind of poor decisions. And that is just to say that people refine that skill across time. You get better at it. And I think we put an unfair presumption a lot of times on people with disabilities to not make a bad decision as soon as they turn 18. And that's just really not fair because we don't do it for anybody else. So this is not to say that guardianship isn't a tool for some folks at some points. It is another tool in the toolbox, but just kind of thinking critically about when it is when it's necessary. It's good to let people kind of refine that decision-making ability across time, just like anybody else. People have different ways of communicating. It doesn't mean that they can't express their choices, wishes, and preferences. So Susan communicates bouncing her foot, using eye gaze. She communicates, though. It's pretty clear. That's, a different way of communicating, but it's, still communication. And to whatever extent she can communicate, then we should respect her wishes and her choices. And I think that's something everybody can kind of agree on. Because ultimately, right, we are our choices. I decided to go to law school. I decided what to wear today. I decided what to eat for breakfast. That's key to my identity and who I am as a person. And that's something, being able to make those choices is something that's really important. So that's why supported decision making is great. Studies show that if you exercise greater self-determination, you have better life outcomes. Kind of work through these, they make sense. You're more likely to live independently, more likely to be employed at higher paying jobs, more likely to identify situations where you could be abused, and less likely to suffer abuse. And that, if you think about that, that makes sense, right? Because if you give people the tools to say, your opinion matters, your voice matters, we're listening to what you're saying, they feel more empowered to step out and say, and advocate for themselves if something is happening. Have greater financial independence and greater community integration. So back to Susan, how can supported decision-making help Susan? So we don't know if Susan can make a power of attorney. Maybe she can, maybe she can't, depends really on where we are. But she can indicate who she trusts. And maybe if we had supported decision-making recognized, she could appoint people on her team and say, I'm happy where I am. This is how I express happiness. I'm happy here. I don't have any friends in Cumberland. I don't know anybody. None of my services are there. I don't want to go. And maybe that's a tool to help her avoid guardianship. Maybe limited guardianship is something if there's finances involved and she can't get that. But for the decisions that she can make around, where she wants to live, what she wants to do with her day, she should be able to keep that. So what are some other alternatives to guardianship? So supported decision making is one. It's not recognized in law, but it's in Maryland right now. But it is a tool that you can continue to practice, even if there's no law that recognizes, an agreement as a supporter. But there are also other alternatives. Yeah?
I just want to say the goal is at some point that hopefully Maryland will adopt.
Yes, that is the goal.
So when you talk about starting to practice and talk about it, the more people that know, the better the opportunity will be for the legislature to adopt this.
Exactly. Education.
What do we need to do to help that?
Give me your name and number.
I'll give it to you.
Yeah.
I very much like
Yeah. No, it's actually I always say in that list, I didn't list everybody, but Texas was actually the first state to pass in 2013. Then Delaware, DC has a law. Pennsylvania has court decisions that recognize supported decision making. Basically and Virginia has done a study on it and has a bunch of court decisions that recognize it as well. So basically everybody around us has done something about it, but we haven't yet. So we're kind of behind the curve a little bit, but that's a benefit too, because we can learn from other people's mistakes and not make those. But yeah, the hope is that, through more education, this will be something that can be put into law one day. There are other alternatives if people are able to kind of understand the legal document. Going back to that difference between capacity and legal capacity, right? A person like Susan may be able to indicate her wills and preferences, but she may not have legal capacity to make certain legal documents. And that's, where we kind of are, and that's where supported decision making may help. Maybe if Susan had some supported decision making, she could understand certain, limited documents. People can make powers of attorney. They are, a great tool for financial decisions, for medical decisions. They can be very simplified. There's a lot of legalese that goes into powers of attorney. They can be made very simple. And, I always joke, my dad signed a power of attorney appointing my mom to be his agent. And then he had me look it over after the fact, and I turned to him and I said, "Did you realize what power you gave her? She has power. She has power now over all your finances." And he was like, "I didn't know I did that." And I was like, "Should be under guardianship. What's happening with you?" You really have to walk through each thing, and you can strike it. There's certain things you can strike out if the person's not getting it. it does mean that your power of attorney would be limited, but there are ways to kind of simplify it. Consent to exchange information, right, I do those a lot in my job. People don't have to, people generally just have to understand I want this person to have this information. And they should have their supporters with them to kind of translate to you, no, we're not getting it, yes, we're getting it, how is it working? Because like I said, if Susan walked in my office and was bouncing her right foot up and down, I would think that she was nervous and not getting it. But actually it means that she's happy. So that's one. Person-centered planning. If you're involved in the DDA process, it's a big push for person-centered planning. Supported decision-making, you can use it for anything. For financial affairs, you can use special needs trusts. They basically allow you to put money away for a person, usually larger sums of money, sometimes houses, the whole things that you should talk to estate attorneys about, not me. ABLE accounts are a great tool where people can put money away. It kind of has built-in ways to manage it. Medical. So there's advanced medical directives that you can make ahead of time. So if this is, if you can indicate, I want this person to make medical decisions for me, if I'm not able to, then you can sign an advanced medical directive and that can come into effect when the person's unable. Yeah.
So, I just want to make sure I'm understanding
Yeah.
correctly. Under power of attorney, there can be power of attorneys that are very limited, maybe even just medical decisions.
Mm-hmm.
So is there a reason we might prefer a limited power of attorney versus an advanced medical directive? Or are they essentially boiled down to about the same thing?
They essentially boil down to about the same thing. It's just, there tends to be more there's a statutory, so what happened in Maryland was, it started with banks. Banks weren't accepting people's powers of attorney all over the place. And so legislature got involved and said, we have to create a standard form. And if you see this, you have to accept it, as long as there's 2 witnesses and all the requirements. So the benefit to the power of attorney is that if you have that standard form, you're good. The standard form doesn't work for you, you can customize it, but that brings you into, there's already some tools that are accepted in Maryland, like 5 Wishes, which I think is in the back, for an advanced medical directive. That's an option. So there really isn't, once you get into kind of a limited power of attorney, if you're changing that form, you can kind of go either way. It just is about, what's easier for the person to understand. And there's also advanced medical directives for mental health treatment as well that come in. Like if a person's having behavioral problems, it falls under mental health. It's often they have it's called Ulysses Clause, usually in law, which is the reference to Ulysses. But basically means that you can decide in advance when you're found incapable of how you want to be treated with psychiatric care. So for maybe some people with autism who have certain behaviors, that's a tool. If a person doesn't have legal capacity, so if we're saying, we don't know, yeah?
Sorry, before you do that.
Sure.
So a HIPAA agreement,
Mm-hmm.
because I know when parents call, a lot of it is, well, the insurance company won't talk to me.
Right.
Or the doctor won't talk to me. So if there's child, whatever it is, the
Mhm.
family member was able to say, I want to share this information, they could sign a HIPAA agreement.
Exactly.
Which would then give the parent access to all their medical information to take away one more barrier.
Exactly. Yeah. HIPAA and HIPAA should have been up. I should have broken it out under under consent to exchange information. You can sign that HIPAA form, and that will give you access to someone's medical records. Also, ironically not up here, is, which I don't think is on the next slide, no, is Medicaid, authorized representative for Medicaid purposes, which should be up here.
It's
So
on the
that,
next slide.
it says,
Thanks, Representative Payne.
representative, or that's for Social Security. But because usually for Social Security, they're kind of broken down of if you don't have the legal capacity or if you do. If you do have legal capacity, for Medicaid, it should be under medical, you can appoint a Medicaid authorized rep. It's very simple. The person can just say, effectively, I want you to make these medical decisions for me. Or if it's about DDA services, I want you to make help me make my decisions about DDA. And you sign the Medicaid rep form, and that gives you authority. Yeah.
Yeah, I'm sorry.
No, this is great. Yeah, that's great.
So the consent to exchange information, that term is new for me.
Okay.
So is that a form that covers lots of different things, or is that just sort of the concept?
It's just the concept. I just lifted that language because it's our consent is titled in consent to exchange information. So it's just, a HIPAA, it's FERPA, it's, all of those consent forms if there's a doctor, yeah?
Is it like, he was at the doctor one day and I had said, I don't want to have a problem with this. Since he's with me, can I just sign off on something you put in his chart that I'm allowed to talk to him, and he okayed it? So is that what you're kind of
That's kind of, yeah, you can use that. Sometimes when they have, when I've been to the doctor, they actually say, who are we authorized? They have a line that says, like, who else is authorized? Who are we authorized to talk to?
Okay.
My mom's a nurse, so sometimes when I was growing up, I always just put my mom. So that would be a consent. You could do, that's a basic consent, what you just described.
There,
Yeah,
so-
and he said, I want mom in the room, sign. It
And
works
then
as a
you do that
consent.
in the beginning with each one.
In
of
the
your
beginning,
doctors
yes, so that
to
you
make
don't
sure.
have to, yeah.
Okay.
Do you have a question?
So the Medicaid authorization,
Mhm.
because you're doing so much at one time when you get into that Medicaid DHS age. and all that
Yeah.
stuff. That's not something that automatically was part of the paperwork then? That's something I probably need to seek out
That's usually,
separately?
it's, yeah.
It should be on, I'm sorry.
No, go ahead.
I do redeterminations all the time.
Yeah.
And it should be on the forms.
Whether,
Whether they-
It was
yeah.
an authorized representative.
Mhm.
When you fill in that person's name, and then you can check what authority you want to give them.
And it's hard to find, I've actually tried for different clients to find a solid form,
yeah, because
and I haven't seen it.
Is what his card came on, was perforated and it just punched out a piece of paper, and other than that.
Usually if you call them and say,
How you want.
yeah,
You can't even get it online.
that would explain why I haven't been able to find it. So yeah, if you call and say I want to be, usually you only encounter it when I was doing work previously that required me to be authorized rep for people. I only encountered it when I tried to get on the phone and no one would talk to me, and we'd have to go through the process of saying, no, I want Megan to talk.
Yeah, I mean,
I want
guess
him on the
I
phone.
just assumed it was part of what I filled out when whoever helped me apply for Medicaid.
There is,
But I honestly don't know for sure.
so what's funny is that you can be an authorized rep for very limited things. So you can just be an authorized representative for, just for the application. So that doesn't cover then all the decisions, just the application part. And then you can be an authorized representative for the appeal process, but that again doesn't cover the actual making all the decisions. So it's just important if you call to make sure that you're on record as the authorized rep, because then you can sign.
And that's what I'm asking. I'm asking, when I call, I'm trying to find out if he has an authorized representative. Are they even going to tell me that if there is?
He
authorized
probably should be calling, and he can call and say, I want mom to be my authorized rep. You can be on the phone. Usually they start out by saying, when I did this in Virginia, they would start out by saying, do you want, they have the person call in, I'd be there. They would say, do you want Megan on the phone? Say yes. And go through, do you want Megan to be the authorized representative? And yes. And it's a fairly simple process, but you do have to understand in a basic way what you're doing, right? It's not something that you can do if you don't have that kind of capacity. If a person doesn't have that capacity, there are still options that aren't guardianship. We do have some tools here in Maryland that are pretty cool. So generally, you can use person-centered planning, and that can be a tool to kind of get people to a place where they might be able to make more decisions. especially if they're using the team around them. Supported decision-making is always an option. It's always something that you can use even if someone doesn't have that legal capacity. You can kind of start building that up across time. Limited guardianship. So this is kind of a last resort. We unfortunately don't see it as much as we should. But to go back to the beginning where I said, sometimes people can make some decisions but not others. You can have guardianship that's task specific. So if let's say you want to set up a special needs trust, I don't know if I would understand how to set up a special needs trust. Maybe I would need a guardian for that. You can just do, guardianship for that specific task. Or you can just do a guardianship of the property, just only over the finances, not over anything else. Use Maryland's surrogate decision-making law for medical decisions and be okay. You can have a representative payee for Medicaid, for Social Security. Usually you have to be found incapable of making your medical or your financial decisions, and then you get one appointed. In the medical context, we've talked about the surrogate decision-making law. It is a tool in Maryland if you're found incapable by 2 doctors, which unfortunately isn't as hard, or fortunately isn't as hard as one would think usually, especially in the disability world. There is there's sometimes unfortunately a stigma around certain disabilities, and it'll say, well, clearly they can't make a decision, and so this will come into effect. But it only happens if the person lacks that legal capacity. So two doctors say, I don't think so, and then you can make a medical decision if you're in that list. And there are resources that I can kind of send out. Like I said, the Attorney General had a guidance on it. We have a letter that talks about using friends as surrogate decision makers and how that works. We have a fact sheet on it too. So it's still good law. It definitely is still a tool to use if someone doesn't have the ability to make those medical decisions. So takeaways, people communicate and express preferences in different ways. It does not mean that they cannot make decisions. Oftentimes it just means that other people may not be able to understand them as well. Ultimately, right, just like for any of us with or without disabilities, the people closest to us know how we communicate our preferences and choices, how we make decisions. And so they're the ones, that are going to be best able to communicate to others what we're feeling and what we're saying. Everyone uses supported decision making, regardless of disability. So something that was great when I worked in Vancouver was that everyone on staff had a supported decision making agreement. It didn't matter if they had a disability or not. It just was this legal recognition of, I want this person in the room with me. I'm going to give that person, special authority to help me. The supporter's role, like I said, it's all about asking questions, listening, providing advice if you're asked, working through consequences, and really respecting the person's decision. Sometimes people make bad decisions. It doesn't mean that they lack the ability, legal capacity to make decisions. It just may mean that sometimes we all don't make great decisions. But again, if you use something like guardianship right off the bat where it isn't necessary, you could kind of inhibit a person from being able to develop that decision making across time. You're probably all doing supported decision making already. It's something that everybody really does in talking through with their loved ones. I used it to figure out where I was going to rent an apartment in Baltimore. I used it heavily in buying a car because that was a very intimidating process that I never want to go through. Taking out loans, you do it. You ask people questions, you get their advice, you weigh the consequences, you make a decision. And really, you have the power, and I say it's kind of cushy, but I say it and I mean it, you have the power to really change attitudes. I often see, if you do go into a doctor's office, unfortunately, sometimes people just talk to the supporter and not a person with a disability. You can start changing that attitude by saying, well, I'm just here supporting this person. You should ask the question to them, and then I can translate, or we can kind of figure out, together, what you might have to repeat for them to understand. But it really is, we always say in the disability field about shifting that paradigm, fancy word that gets reprinted fancy phrase that gets reprinted all the time. But it is about really changing attitudes and getting people to recognize that some people communicate in different ways, may need more time to understand things, doesn't mean that they won't get from point A to point B. What can you do now? So supported decision making right now isn't the law of the land. Again, it doesn't mean that you can't use it in Maryland. You can promote self-determination, so ask questions, listen, recognize when there's a place for someone to take risks. Help someone create an expression of my wishes. So the document that I read in the beginning, which unfortunately I can't disseminate, but if you're thinking about that, especially if you're you're getting into DDA services or you're in DDA services and there's staff turnover and you don't want to send people through the same process of having to have that learning curve with their staff. It would be really nice if you could say, here's how this person communicates, this is what you need to watch out for, this is what this is how they indicate that they're happy and sad and make choices. If someone presumes that someone you're supporting is incapable, try to put that hat on as a supporter and change that dialogue a little bit. Sometimes if you're in those crisis situations, that might not be the route that you can go. And doctors don't always have infinite amounts of time, but where you can start to kind of infuse it. And that's really what starts to shift the dialogue around this. Really educate others about this practice. We're trying to do broader public legal education around supported decision making as an alternative, really encountering a lot of people. It's a new term, but it's something that we all do. It sounds new and different, but it really is just trying to legalize a process that we all do every day anyway. And then these are a list of resources which are in the PowerPoint, and you can also contact me. There's a national center on supported decision making that kind of tracks what everyone's doing across the states and has a number of videos that are really great, and as well as just general resources, guides. The American Civil Liberties Disability Program has kind of a walkthrough about why it's important. The Autistic Self-Advocacy Network, ASAN, has great resources and toolkits that are really simplified. They have a disability-friendly toolkit that can help people pick supporters and walk people through that. So they have great resources. And then it's in the back, but on Maryland-specific resources, the Guardianship in its Alternatives Handbook, Maryland law, is a great resource. It doesn't mention supported decision making, but it walks you through those alternatives and what the law is in Maryland. We have a link on our website, although it's kind of hidden on the resource page in a sea of links. But it is a fantastic resource. And I think I deleted the question slide, but we can go to questions. Yeah.
So when you start to ask around on these things, you get two definitive camps. They are either diehard guardianship is a must, or they are diehard, I would never do guardianship in a million years.
Right.
To me, if you're not seeking guardianship, which so far we haven't, and we basically are what you're talking about without knowing there was a title to it.
Right.
It's what we're trying to do our best, plus have some things in our wallet, like the
surrogate
or whatever that was called, in case we were in that kind of situation. But I can't say the guardianship has ever completely been out of my head, although it's pretty small. What is it, that camp that is like, I would never do guardianship? Why? And it's not about the money. It's not about attorney's fees.
Right.
It's about something they're fearful of. What is that about guardianship that is makes this parent feel like they're suddenly very fearful of, I guess, the state ultimately
Really being involved.
being in control? Is that the bottom line?
There's a lot of things. Yeah, and I'll let you jump in and then I'll jump in too.
Just as
Yeah.
we are fearful, is that the dignity of the person is like a big one for us because our son is very verbal and has a lot of capacity
Mhm.
in some areas and then very little in others. So for us, it's like that's like the biggest topic. His dignity
Yeah.
and his independence.
Because you're basically going to court to declare that person who you love incompetent,
Yeah.
and our son knows what that means. And that would be
So
to
that's
us
for
a
us,
big
that's
blow
in
to
our-
his
Gotcha.
self-esteem.
Yeah.
That's our concern.
So yeah, it's really that, and people don't always think about it. They think it's a benevolent, happy thing, right? It's guardianship. It's what I was for my parents when I was 16. It's the same thing. It's not really, because you have to go to the court, and the court, there's an attorney for the person with a disability. There's an attorney for the person seeking guardianship. And it's an entire court process about how that person can't make decisions. And once,
I'm sorry, what happens, say someone's granted guardianship,
Mhm.
what happens when that guardian passes?
That's a great question.
Is that one of the fears?
That's
There's
one of the
someone
fears.
just out in the
So that's one of the fears is that, so there's two things. The first is that it's very hard to undo. So in theory, you would think that you could march into court and say, well, Megan just, needed to mess up at 18, but she's fine now. Look, she can make her own decisions. She's living in a group home. She has a job. You would think that would grant, be a path to saying, no, Megan can, make her own decisions. She doesn't need to be under guardianship. But it is. We see a lot of people who come to us saying, I want my rights back. And in my opinion, if you're saying to me, I want my rights back, you probably should have your rights back. And they can't get it because the burden is very high. And you basically have to, it unfortunately has come down to proving that you'd never make a bad decision. And then the other thing, which you've hit on, is that guardianship, because it takes away it takes away a person's ability to make all decisions. If something happens to the guardian and there's not a standby guardian, there's not like a line of succession, and children are outliving their parents, people don't really think about that. But, people with disabilities are living much longer. If the parent's not around, then the person can't make legal decisions. And oftentimes that inevitably will lead to the state stepping in and being public guardian.
Is applying for guardianship, does part of that process allow for a line of succession?
Yeah, you can appoint other people, but it is, to the other point that you made, a very intensive process that requires you to report every year. And the court's the ultimate arbitrator. Like there are certain actually, and I hate to actually forget the decision when I'm being recorded, but there are certain decisions that guardians can't make that surrogate decision makers can make. So there are certain things you have to petition the court to do, whereas if you didn't have guardianship, you wouldn't have to. So there are those drawbacks. I see it often rooted in, the fear rooted in, well, right, it's going to take away this person's ability to do anything. And then some people, some people say, well, that's exactly what I want. And that's the harder, that's where you're really trying to get at, well, what is it? What is it about the decisions that they're making that are troublesome?
But for somebody that maybe is not so as competent per se, if a parent decided to go for guardianship, that court decision could include, if I die, then so-and-so is guardian. And the court could approve all that right then and there.
Yeah.
Or if the guardian died, all of a sudden somebody's got to go back to court and be like, I want to be guardian now.
So you can appoint a successor guardian. You just have to make sure that the person is on board with all the report. The court would honor that if it's a successor. You would just have to provide a death certificate usually.
But what Okay, so then she passes away, and the next person she puts on that list,
Mhm.
does then the courts have to meet that person and still approve that person, even though she appointed them?
No, that would be a great safeguard, but it just you probably just provide the death certificate and you're okay to go.
But that's because they're kind of making that part of the whole approval package in the beginning, right?
Right, and they're just saying the person can't blanket make a decision. Now there are some tools that help you kind of walk through guardianship. There's the forgetting which work group did it. I think it's the vulnerable adult. The judiciary's vulnerable adult work group has some videos that you can watch that are really. They were noticing that guardians really weren't understanding what they were getting themselves into, and that kind of walks you through what the responsibilities of a guardian are, because there is some not necessarily liability, but you're on the hook for making all these types of decisions. So, that's the reason why, if you can, I always say, use, to every hammer, everything's a nail. Don't use a hammer or a sledgehammer when just a push pin would work. If the person can understand certain things and you think it's just a matter of time, or there's certain decisions they can't make, but maybe there's a tool that allows you to make it for them, you don't need to go the guardianship route. And I like to point out too, I don't know, there are people who communicate, and some of them now are the leaders of our disability movement who communicate with, have like a headband, and they use a computer screen and they type out their words, and the computer speaks for them. Well, 30 years ago, we would put that person under guardianship because we could say, well, I don't know, we don't have the technology to understand you yet, right? There's Nicole Jorwick, who is one of the public policy people at the Arc National, talks about her brother and how, before he had a communication device, that was, he was communicating through gestures. That was how it was working. And, I just kind of planning that idea and in your head and saying, well, we also don't know what technology is going to look like 30 years from now. And maybe people who we're assuming can't make decisions. And really, oftentimes it isn't the people closest to the person. It's third parties like bad attorneys and some doctors and other professionals who are saying, I don't get it. Maybe 30 years from now, if we have different technology, we'll get there. We see it with iPhones that are helping remind people to do things, right? Alexa and all her powers. Like there are tools that we've developed that are really helping people, stay on task, make decisions, get there. And that's only, I think, going to increase. So, when you're thinking about that, thinking down the line of, if I do this, it's pretty much permanent. I don't like to say, because I want a job as an attorney to restore people's rights, but it's very hard. And even with, in some states, even with the parents saying, I want to give my child back their rights, courts even still say no. So before you go down that path, think about whether there are other alternatives. Any other questions besides my ranting? Yes.
I raised an autistic grandson.
Mm-hmm.
From 2 years old, now he's 13.
Mm-hmm.
And I paid the lawyer for the guardianship. So I'm the legal guardian because my son and his wife divorced.
Mm-hmm.
He's in the military.
Mm-hmm.
So I'm in position to make a stable life for my grandson.
Mm-hmm.
So now he's 13. Do I need to do anything when he's 18? He's pretty smart. He say everything.
If he can understand everything. See, that's the tricky thing about guardianship. So you're guardian now because he's a minor, he's a kid. Once he turns 18, you would have to go to court to continue guardianship. But if he's able to understand things, he may not need a guardian. He may just need like a power of attorney. Does he have trouble making medical decisions, or does he get it?
It doesn't make sense. Sometimes it doesn't have common sense. That's all.
Yeah.
He's frustrated easily. He change from day to day, the same thing, you know. If he didn't want to go to the dentist, he won't go.
Right.
So it doesn't make sense sometimes for this artistic mind.
And you know, that's something, you know, when he turns 18, because a lot could change, right, between now when he's an adolescent and when he's, you know, built up in school and can kind of make decisions. And so when he turns 18, you can see if it's something you need to do or not. You know, I think that there are other tools, you know, like if he's having trouble with medical decisions. I mean, dentist is funny because my partner will not go to the dentist at all. It's been like 5 years. Will not go. Right? People, you know, people kind of make those decisions. If there are certain medical decisions that he needs to make, you can maybe use the surrogate decision-making law. You can use advanced medical directives. There are a number of other tools. Right now, you're a guardian because he's a kid. But when he turns 18, you know, he'll be able to make his own decisions. So it's just about finding what tool works best for him. That makes sense. Any other questions? Yeah.
Hi.
Yeah. No?
So I wanted to go back to the right to do or don't do guardianship just for a minute to ask you a question. So a number of the families that we work with have children that have dual diagnosis. And there would be an issue where sometimes their kids are aggressive. And so one of the questions that has come up about when they turn 18, if the parent has guardianship and their child becomes aggressive with someone else, and that person decides not just to call the police, but to say they're hurt and they're going to sue or something along that line, because that seems to be how our society works.
Yeah.
So if the parents have guardianship, would they then become financially responsible if someone?
I mean, that's a tough question that I actually have to look into because it's a really good question. Because usually it would be the person's money first, and then the thing is under guardianship, usually you're just guardian over the person's own property, so it doesn't have ties. Now, if there's like a joint bank account or something like that, then you know that brings in other laws. But I don't know if I have the precise legal expertise to answer the liability question.
But it sounds like a foothold for so happy people to make your life miserable for a while,
Right.
even if the ultimate decision ends in your favor.
Right.
That would be my opinion. Sorry, pessimistic opinion, I'm sure, but it's the world we live in.
Yeah.
Because they're going to find an attorney shady enough to try
And get after,
push something,
push you.
whatever they can, even if there's not a true legal basis in the moment.
And there are sanctions on guardians, like if you don't do your duty, that you are liable. It's a lower standard, but if you let the person run out with all their behaviors and don't do anything, then you could potentially be liable if you're not providing enough support. So there are, because it's a court process. I mean, people always say I'm my son's guardian or I'm my daughter's guardian, and really ultimately the court is the guardian, right? It's not, you're just a place filler, right, until there has to be someone else, or you have to always report back to the court about what you're doing. And that's a lot of people's aversion to it, is getting the court involved.
In that context, then, of her example, would it just go back to the court? Really, how could somebody hold the guardian responsible if, in fact, it's the state that's...
Well, I mean, it's the guardian as the actor for the state. So the court would go back and say, you're not doing your job, I'm going to sanction you as guardian. That's what they would do. Which I have to look, before I provide a lot of advice on that, I have to more look into what the consequences are. But I know that there are, if you fail, if you don't report, if you don't manage the person's money, there's safeguards. So that's another tick in the against column. Yeah.
Sorry.
Yeah.
And so you went through your resources, and I just wanted to add that I stock, or put another page out there that has some additional resources.
Oh, yeah. It's in the back,
That we use
which
a
I
lot
didn't
that
say.
we give out to families, which has the Attorney General's website, which has
Which is
really
great.
great information on it. It walks through an advanced directive. There's a video you can watch. It's got sample forms. And it has 4 other places that do advanced directives. So while I have sort of a captive audience, you know, if we're talking about taking care of your child, if you don't have an advanced directive as a parent, you really should have one. While you're looking at all this information, the People's Law Library
Has fantastic
is great.
person-centered.
It's-
Yeah.
I can understand what's there. So I think that that's really good. And then I put a couple of planning websites because you're talking about guardianship, but there's so many other things that are all part of this moving into adulthood that as parents or family members that you have to think about, that I kind of added all of that also. And my last thing is, while you were talking, I gave out evals. One of the things on there is we're doing our planning for the fall. And we actually offered about 12 workshops in the last 8 months. So we're trying to figure out what we want to do next year. So if there's specific topics that are of interest to somebody, we would really appreciate any input as we start developing our plans for September. No, I'm done. Thank you.
Okay. No, that's it. Yeah.
So I guess my last question would just be, because I'm not one who thinks they'll ever be on the guardianship track.
Yeah.
We're already essentially doing supported
Yeah.
decision-making in a way without realizing it had a title. I carry that one statute in my wallet as far as Maryland law. What would you say, I mean, I guess I'm just saying, are there any other particular documents? And for me, it's more about those things like emergency type things. Is there anything else you can think that we should have, just so that if we get in a situation where we need to be able to make a decision that's just too above his competency? Because that's my young adult is in this gray area.
Right.
Of, it's just a gray area. I mean, there's some decisions that they are totally his. It's clear he understands the question we're asking. You know, but you get in an urgent situation, that can be a whole different story.
Yeah.
He might not even be alert. It might not even be a competency thing at that
Right.
point, as much as
It's just
not
that he's not
alert.
able. Yeah.
So I feel pretty good having this in my wallet. I haven't had any of the horror stories yet about a person saying they won't talk to me. I guess it's because he and I are always together for doctor's appointments and things, so I
Yeah,
guess they
that always
just
helps.
don't question it. But I can imagine I could get on the phone at some point and have somebody say, can't tell you.
Yeah.
So is that where I guess the HIPAA, maybe the HIPAA form would be the other thing I
HIPAA
should
consent.
check on?
Yeah, I would say the HIPAA consent. It really depends on what. The medical decisions tend to be literally the life or death thing that scares people, and that's where the surrogate decision-making law helps. The advanced medical directive, like 5 wishes and things, can also give him kind of the ability to walk through some of those decisions and choose his preferences. And then you would, that's also another option. And those are easier. You don't have to go to an attorney for those. If there are certain decisions that you're specifically worried about, you can have powers of attorney that come into effect if he's incapable. So about some of the financial decisions, I would.
Will HIPAA cover the Medicaid
It'll let you
representative issue?
get information, but it won't let you act. So if you have to,
Okay.
let's say he goes into the hospital and something, his plan of service for DDA has to be signed.
Okay.
They're gonna probably create a stink unless
Yeah,
he
but
signs it. You'd have to be the Medicaid authorized rep. They shouldn't because they're supposed to be person-centered, but just saying that they may. So that could be a situation.
Like she said, if we die,
Mm-hmm.
if we leave guardian now, should we put on paper now that if, in case I die, who will take care of the child?
There's a lot of planning documents that can help imagine and I don't know if the DD Council's document does this, but not necessarily for guardianship, but just who you want to be on that person's team, like to help them make decisions. You can write down, if something happens to me, if you make an expression of my wishes, this is how, my grandson communicates. This is who he likes and wants involved in his life. This is not who he wants involved in his life. I think that, if there are people, if you can document who he wants support from and who he doesn't, that would be helpful, for sure. Did you want to add in?
Do I need to pay?
So not if you're, see, right now you're guardian. When he turns 18, you won't be anymore. He'll be his own person. But
Under 18, I have to pay everything.
well, that's a good question. I don't know that fully, because that is the requirement that plays into family law a little bit. But usually parent has an obligation to pay for their child. And so but with grandparent, it's a little tricky. That's a little tricky for me. Unfortunately, I only know small areas of law. What were you going to say?
I was just going to say, it may sound very naive, but our common sense, we just had a pseudo-emergency. I probably could have called 911 because there was an aggression issue. Anyway, but that led to us having the conversation with our son. You need to wear a medical alert bracelet. And I know it sounds corny and a big deal, that doesn't give you any legal right. But and he's okay with it being outward. I thought he wouldn't want anyone to see some of his diagnoses on there because some of them are psychiatric. But they do sell them with, the symbol on the outside and then the type on the inside. Because I just think I'd like to appeal to people's common sense. If I'm with this person in the hospital, he's got this bracelet on, he might not have the same social behavior.
Right.
Again, it doesn't give us any rights, but I just feel like, I don't know, maybe you would disagree with that because
People that don't know any better
he
for
knows-
sure might
Yeah.
just see that and
Yeah,
think,
and he knows
Right.
enough, like, wow, I could have gotten into a really sticky situation because there is no awareness right in that moment that
yeah.
I might have some other
My
things.
son has this bracelet, we got him years ago.
Same
It
idea.
actually has his name, it has my name,
Right.
my cell phone, his dad, and he loves it. We had it for a long time. Right, is it your bracelet? Yeah. And it's kind of cool looking, because no one really knows. But you can put some, you can even print on the inside.
Well, bikers
Yeah.
wear them. I'm on the website, right? I wear
Yeah.
it from Road ID. And people that bike or they're out by themselves, they
Yeah, I mean, you
So-
have it in your, I'm allergic to penicillin. I put it in my wallet just in case, The same thing with allergies. I mean, it is something, there are other tools that we can use that can kind of alert people, but that's really where it gets
My
at.
document, the bracelet, it's just like I'm kind of thinking that might help tell a story in a
Right.
Exactly.
situation.
Exactly. And that's, I think, brings it to a really good point of saying, really what our job is now is to educate people about the fact that people can make decisions, that, in times of stress, people may need support, and you're the supporters in that. And the more people do it, the more, you're, with him in the hospital and he has this bracelet and there's and the doctor's going, okay, well, this is cool. Maybe I'll remember this for next time. The more you start going down that path, the easier it is for other people, right? To not have to go the guardianship route, for doctors to say, okay, well, right, I just need to, talk to the parents a little bit. We'll work out, they'll help translate. We'll get there. It takes more time, which everyone is short on these days, but it's, that's the difference between someone having, the right to make their own decisions and not. So I think it's a big thing. Yeah.
sorry, I said it was my last question.
No, it's, we had,
This is terrible to admit, but a lot of times, like in the doctor's office, I just sign my name, and it doesn't even get questioned half the time. I'm assuming, I guess I should be having him.
probably
Like,
should be having him
sometimes I
say.
am, because I feel like I have that minute to explain to him what he signed. Like, I always want to explain to him this is what you're signing,
Mhm.
if we're at the doctor or whatever.
Yeah.
Sometimes just in a rush, or if it's just like, we were there to get I don't know, bug light looked at or whatever, like, I'll just sign it, because
Mhm.
they're gonna take
Yeah.
it back. But I'm guessing I should kind of stop having that back and forth.
Yeah.
Just make sure he signs.
And he understands.
things.
Like, you want to make sure that it's not the opposite end of the spectrum. Or sometimes I see people say to me, well, if you put anything in front of, Megan, she's just going to sign it. Well, you don't want to encourage that. But, if
Well,
you
I'm
can
just
take the
saying,
time to,
like
yeah.
that Print out the the receptionist prints this thing out for you to sign that it's all the right
Right.
medical information.
And you have to go through it all. And
or-
maybe, you can have, if it's something that's standard like that, where, if you're going to the doctor every time, they're going to say, and you can say, hey, this is just that same form we talked about last time where you just need to make sure everything's okay and have him sign it. But it's probably better.
You just
Yeah.
made me think of something. Like, they don't do this in the schools. They
No.
should be doing this in the life skill schools, teaching them that.
Mhm.
Growing, you know what I mean? You don't even think about that.
It would be
But-
a really
Yeah.
good IEP goal.
Yes, and the one thing, like, it drives me nuts even in the schools, they'll ask me what he would want. I'm like, well, why didn't you ask him?
Yeah.
No, like, they don't even, and this is like special educators, like, you don't even have that, but that training should be started.
It's a blessing and a curse, but in Maryland, and I guess because it's FERPA more generally, or IED, parents retain the educational right to make educational decisions in special ed
Yeah.
under the IDEA until 21, so they're or 22 when they really graduate. So they'll just automatically turn to you and go, well, what does he want? And it doesn't build that up, right? That decision-making capacity. And that's what actually DC, their supported decision-making law is all about education and putting it into IEPs and getting people, really thinking about it. Because, that's when it starts, when you're getting ready for that transition.
Yeah.
You need to be building up those skills. And it's, I feel like transition now starts at 5, but, we're, it does, you do need to kind of work on that before, so.
But it could be a goal.
Yeah.
Oh, yeah,
I mean,
yeah.
because IDEA says it prepare for independent living.
Right,
Mhm.
So that would be something that the person would need.
exactly.
And there have been people who, in different states where they don't have supported decision-making laws, where they will make agreements, get them notarized, and try to use them. And sometimes they're successful, in saying, because you're not giving the person any legal authority to make decisions for you. You're just letting them be in the room and help you think through situations. So, you can practice that informally in saying, who would you want on your team? Who do you want help making these kind of decisions? Who do you want help, making financial decisions, medical decisions, decisions about your personal life? You can start that planning now and kind of work out who somebody wants on their team for certain things. And that, that can just kind of help down the line. Even if we don't have a law, you can kind of be using that as a tool now. Because like I said, it's more, the way that we're going to win this thing is we're going to get it more and more visible. So people are just seeing people act as supporters as opposed to somebody making decisions for someone else. So I think that's important. Any other questions? It's been a great question group. Yeah.
Okay, so I'm just wondering, I don't have you gave one example in DC that it applies more to education. I guess I don't have a good feel of what the regulatory consequence is to it. Say we do have a law, say we have 10 laws. How does it affect what a person can do with a bank, with a health provider, or anything else, their estate,
Right.
or trust?
So with estates and trusts, it's a little more difficult. But with like a bank, what you could do is say, if I Megan wanted to appoint my brother as my supporter, I could sign a supported decision-making agreement. And the way they usually work is that you indicate for which area, they break it usually out into areas of your life and different types of decisions. And then for those decisions, you can say who you want to be your supporter. So for financial decisions, I could say, well, my brother. And then if I need to make a withdrawal from my bank account, and maybe I'm not like feeling that great that day, it's, I don't want to do it, I need help doing it, they can come with me. And the hope is that if it's legalized in law and the agreement is legalized in law, then banks are more likely to accept it because there'll be a standard agreement, just like there is a power of attorney. And it'll say, you'll go into the bank, or my brother will go into the bank with me, and maybe I'm not withdrawing money, he can walk me through it, and he can be there with me and help me understand the transaction while it's happening. And then this way, if I have any questions, he can help kind of be the translating party. Same thing for medical decisions. So the way that they're working, and each state is kind of doing them a little differently, although unfortunately every state's kind of now just copying one of two models. You're either the Texas model or the Delaware model. There's no real creativity in there that's specific, but you tend to pick your areas and what you want help with, and pick your people, and then that gives that supporter the authority to help you make that decision. So it's not this formal, you go into the bank and you can withdraw money for someone else. It's, the person's there with you, you're helping them understand what they're doing, and you're getting there. So does that make sense, kind of?
Yeah, I think so.
Yeah.
It seems like a very, again, limited power of attorney or something like that without being as rigorous, of an agreement.
Exactly. It's supposed to be, people are trying to make them much more accessible. In part, that helps lower, right, what we worry about with powers of attorney is that they get so complicated, and then people, then you have people questioning whether someone can make it. You say you can't make a power of attorney. We really don't want that with supported decision-making agreements, right? We want to make it as simple as possible so that, people can always, have somebody at least in the room with them to help. So, and there are different protections states add. So, some states say if you see it being abused, like if anybody who sees this agreement and thinks that someone's trying to influence someone or manipulate someone, then you have to report it. There are states that say that doctors have to honor it. You won't face any liability for honoring it if you do it in good faith. You try to add these things to make it so that they're actually useful and effective. Is kind of how they started to work. Alaska actually has a provision that lets guardians kind of cede back some power to the person. Not sure how it works because you would have to go through a court to get that, but the idea being that you can still use it even if you're under guardianship. So there's a couple different models that are popping up, which are pretty great. So, anybody else? Any questions?
How do we,
Yeah.
where do we print the papers out for power of attorney and the medical directive and all that? Like, where do we get the papers?
Where do you get the
Now,
papers?
what do we do?
So, the attorney in me always says that for powers of attorney, you should, for really any legal document, you should always consult an attorney. That's the legal disclaimer part. I think the statutory power of attorney, I feel like it's online. I know that it's physically in the statute. Yeah, it's probably on the Attorney General's website.
Obviously, Attorney General's website or People's Law.
Yeah, People's Law will walk you through it.
People's Law
Is People's Law Library.
Oh, okay, on here.
And then
we just.
yeah,
that
and those
out.
yeah,
Seems like you email me.
yeah. For guardianship,
But
it's
then
expensive.
What about, like, the power of attorney, we contact an attorney to do?
You can do it on people's. I mean, we always say there's
Where are the
you,
templates?
Yeah, Susie Orman always. But it's very
Yeah.
hard.
The same
It's
place.
very hard.
Try, very
Yeah,
hard.
yeah.
It's complicated.
It is. It's very complicated. So yeah, you can. The templates are online.
We can get a witness and have it notarized.
Did you check with these?
It's there, and then the 5 wishes. Maryland accepts 5 wishes, so that's the advanced medical directive. A lot of people use.
Ah, okay.
And if you, I mean, we usually just say we don't do powers of attorney. Unfortunately, some P&As have helped people make them. Fortunately, we don't. But if you're, having trouble, you can always contact us and we can see if we can make you referral or kind of walk through, what it is, because like I said, they're complicated. You can make them a lot simpler. You can make it apply now. You can make it apply when the person's incapable. You can, have it kind of customized to what works.
So there's no one you recommend to do it?
Well, I can give you a list. We can't make referrals, but I can give you like a list.
No,
Up here, yeah.
The thing is, so we always try and send people to websites because when you start going to private practice, you pay by the hour.
Yeah.
Mhm.
Or the minute, actually.
Yeah.
So if you looked at the information, then at least you're going in making sort of an informed decision,
Mhm.
that you understand all the different things that you're going to be asked. I mean, like, do all this for my parents who were in their
Okay.
90s.
Right.
And it was a lot better to research it and to have advanced directives and know it needs to be in a will, and then understand, to
Yeah.
have an understanding of the things, and even if the sample, because there is a Maryland state
Mhm.
statutory
Yeah,
power of attorney,
yeah.
that at least we knew what it looked like, so that
Right.
when we went, when, for the part that we did go to a lawyer for,
Mhm.
we knew what was there in advance, so we didn't have to spend twice as long, and I didn't really want a lawyer telling me what I should do either. I wanted to have some.
Yeah,
I
no,
wanted to
it
have some
shouldn't.
information so I could make up my mind.
Yeah, it's good to always know in advance. It's good to, try out your attorneys, make sure they know their stuff. If you walk in and someone's just pushing guardianship as the only option, then maybe it's not the right, it's not the right course. And they do because it's more money. So you kind of got to watch out. Powers of attorney are much cheaper.
I have a friend that is basically just using somewhat of a template.
Mhm.
She did get 2 witnesses or whatever, but is she in, for like in a power of attorney type document, is she in a somewhat precarious situation to think that
You don't have to use the statutory form, but people don't have to accept it. So, in law, I think don't want to be quoted on record as paraphrasing Maryland law incorrectly. But I believe that the requirements just lay out, what you actually have to have physically in the document. You don't have to use the statutory form. It's just if you don't, not everybody has to accept it if they don't believe that it's valid.
how do you know if a form is a statute?
There's just one. So it's literally just the one online. People's Law Library will direct you to
I
it.
guess if you had one done by an attorney, most people are going to see the attorney on the letterhead and assume that it's a,
Usually when you get things notarized and it's that,
probably going to question.
yeah, people, especially when you get it notarized and there's the witnesses.
I mean, I'd
and-
like to think that the attorney knew everything to go in.
Yeah, but they don't, right? Like it was funny for my parents, I told them to I was like, I can't be talking about all this stuff and you guys don't have it. So they made their powers of attorney and they appointed me for medical decisions. And they wanted my brother to handle the financial decisions. Very simple. But they actually signed a general power of attorney that gave my brother the power over the medical and the financial decisions. And me, just the advanced medical directive, which didn't have the same, was trumped.
Right.
Like he could admit them into nursing homes, but I could take them after that. And they were like, well, we don't want him making that decision. And I was like, you should have read what you signed. But the attorney didn't walk them through. And it was a notable attorney. He didn't walk them through in honoring what the person was saying. So you do kind of want to go into that with that critical
Well,
eye.
what you're calling a statutory form, and even though there is an actual statutory form,
Yeah.
you're saying as long as all the pieces that make it
Hmm.
the form
Are there?
are there, then it's considered
I-
a legal statutory.
Yeah,
document.
that's my understanding. I would want to just go back and check. the actual law, but I mean, realistically, the statutory power of attorney is new, the form is new, so they have to accept things from before, and so as long as you meet the requirements, I feel like it was 2000 or 2006 maybe. So we provide free legal services, but we don't do the powers of attorney or things like that. You usually pay an attorney to do the power of attorney, but it's cheaper than guardianship. It's not, like guardianship is thousands of dollars, sometimes tens of thousands of dollars. Powers of attorney are a few hundred, depending on who you go to. Supported decision-making agreements, across the country, are free. There usually is that's one of the things that, especially in British Columbia was important when I was working out there, was making sure that you didn't have to go to an attorney for it. Like, it would be nice if you wanted to consult someone, but you really wanted something where, we don't want, just like you don't want the state in your life with guardianship, you shouldn't have to have attorneys in your life at every turn. So the hope is that with that, that'll be something that's accessible, but we have to get it into law first. Any other questions? Yeah?
So how can we help the process move along? Like, is there a list, an email distribution list from your organization or something where we can kind of stay on top of where Maryland is at?
Yeah, I am happy to. So we have a couple of work groups we're trying to start. So I would be really happy to take anybody's contact information who's interested in kind of going out, because when this hits, we'll need a lot of help. DRM partners with our DD coalition, so the DD Council is big on it. So as far as, we're kind of trying to operate as a cohesive unit and also bring people in from across disabilities. So, we're talking in the DD context right now, but it has relevance for people with mental health. It has relevance for Alzheimer's, people who are older, people with dementia. Right, in those situations, it's often it's the people around the person who understand them for the longest period of time, right? Someone may not be making sense to me, but if it's my brother, I can I get him for much longer than someone else. So that's relevant. So as far as right now, getting your contact information would be great, and I can keep you in the loop about, we periodically have meetings to discuss kind of strategy and doing more public legal education around it.
There hasn't been a bill introduced or anything?
No bill introduced yet. We were toying with draft legislation last year and came pretty close, but we countered a lot of pushback from Department of Human Services, some doctors. So it's really going to be about, one, making sure that we're doing this right and getting people involved across the board, and two, just realizing we need to lay the foundation a little bit more and we need more education. So I say right now, the best thing that you could do, it sounds like a lot of you are doing it, is talking about guardianship isn't the only option. You can choose other things, and really getting that out there, and getting supported decision making kind of to be a common term, because it is something that we all do. It's just this new fancy term. So I would be happy to take your contact information, get you guys in the loop.
Do you want people to email you?
Yeah, that would be great, because then it's much better than calling me, because my voicemail is hard to get through.
Your group's funding come from?
So I should have said that in the beginning, and then I realized I didn't. No, I didn't. And that's actually, I usually should open with that. So we are, we're federally mandated, so we get federal grants and some state grants to provide free legal services for people with disabilities. So there should be one of us in every single state. So if you move, across state lines, you should find your local, we're called protection advocacy organizations. And in my office, we work on a whole variety of issues. So we do housing. I work on the DD team, so DDA services. We have a mental health team. We have a community inclusion team, which does some Social Security overpayments and kind of work incentives. So, people getting out of the stigma of, I'm on Social Security, I can never work because otherwise they'll take it away from me. You can definitely work. It's encouraged. You can keep your Medicaid. It's okay. There's that side. And I know I'm always free. And there's a actual Medicaid team too. So our funding is mostly federal, some state, and we try to provide as many free services as we can. And there's no, for my grant, there's no income limit. We serve everybody with a disability. So, anybody else? All right. Thank you, guys.
Thank you. Please do the evaluation.
Yes, this is. Thank you.